bagging it and not leaving the building for lunch, all because of an increase in crime. That's just what's happening in the Bay Area as managers of Kaiser Permanente's national headquarters in Oakland have recommended to workers via email that they have lunch delivered, bring it from home, and not go out due to security concerns. What might be the repercussions if you don't follow the boss's suggestions? Attorney Michelle Trigger here with me live to talk about a suggested new protocol that's gotten some people's hackles up a little bit. Michelle, good morning to you. Michelle?
Morning. Can you hear me?
There we go. You're back with us. Now, this is a recommendation, not a rule, but it was emailed out to Kaiser employees. I kind of feel like there's no way that if people are being encouraged to stay in, that workers won't feel like someone's going to be watching the doors at noon to see who's bucking the suggestion and that your name might end up on a list somewhere.
So this is a challenge that I think most employees at some point in their lives, at least to some degree, have experienced, which is when an employer maybe has an expectation or a recommendation, and one that if you follow will probably serve you well in terms of promotions and in terms of being well liked by coworkers or the boss, but is not necessarily legal. So in other words, in this situation, they can't tell you that you can't leave or tell you what to do with your lunch period, but we all know how it feels when an employer expects us to work through lunch or to stick around and have lunch with coworkers or to stay a little bit later, and that's going to garner some good attention with the boss, even though we don't truly have to follow it.
What about the concern that if I've been warned, but that I do it anyway, if I leave the building for lunch and God forbid something does happen and I'm hurt while maybe being mugged, might I get some pushback, filing a medical or other kind of claim, that I was acting outside the scope of employment?
It's very possible, and this will be very case specific. So for example, it can be treated differently depending on if you are an hourly employee or if you are a salaried employee, what exactly you are doing on your lunch break. So for example, if you are a salaried employee and you're going to take a walk to a local restaurant, but you're going to take a work call on your way, or perhaps you're going with a coworker, and while doing that, the two of you are discussing work, that can absolutely be considered work related, and thus something that happens to you could potentially expose them to a claim. So it's my opinion in situations like this, the employer's trying to prevent that and trying to at least have some documentation that you were warned against that. In the event that, as you said, God forbid something like that happens, it may at least lessen their liability.
Now, they don't say it exactly, but the strong implication here by Oakland's largest employer is that Oakland is not safe. Might the city have any kind of legal claim based on an entity with the weight and reach of Kaiser kind of casting the city in this light?
It's possible. I would say, based on the memo that I've reviewed, probably not at this stage. But the city is voicing some concern and frustration because if you have a place such as Kaiser that employs thousands of people, those people are going to contribute to the downtown income of various restaurants and businesses. The entire feel of downtown is going to be more positive when you have people contributing to that downtown area. If you as Kaiser are telling all of your employees to refrain from going downtown and telling them, even if not explicitly, indirectly, this is not a safe place, it's just not going to help with a concern that Oakland already has, which is their image of being unsafe. So I understand the frustration, but I'm not, there's going to be anything that the city can do to tell Kaiser we don't like that.
Again, we want to emphasize that this is just a recommendation from Kaiser to its staff. The company saying via statement, quote, in response to the current crime environment affecting all businesses in the entire community of Oakland, as well as communities across the country, we continue to provide guidance to keep employees as safe as possible. And so just to emphasize, they couldn't legally make this no outside lunch a hard and fast rule, right?
I don't believe so. There are some very narrow exceptions where an employer can dictate what you do during a lunch period. If we want to get into specifics, it can be part of somebody's employment contract where you're explicitly compensated during this time. There's a very specific reason you need to be on a premises. For example, if you are a fisherman and you are out on a boat, there's no getting out of the fact that you're going to have to stay on a boat during your lunch period, right? There can be exceptions, but by and large, employers cannot dictate how people are spending their lunch period. Lunch and breaks are for employees to do as they wish. and that's a very important part of most of our employment laws.
I think Kaiser's thinking forewarned is forearmed, and we told you, so don't come back at us. All right, Michelle, thank you so much for helping us understand this and understand the workers' rights and all of this as well. We appreciate you.
Of course, you're very welcome.